All right, now, if there are any people who wish to be heard in opposition, this would be your opportunity. If you step forward, identify yourself.
My name is Richard Litchfield, and I'm here to speak on behalf of Attorney Louis McConey.
On behalf of
Louis McConey and myself. He asked me to read this to the council and then pass a copy out to the council members.
Okay.
If I could do that.
I'm all set. Thank you.
He addresses the Governor's Council, State House Room 184, Boston, Massachusetts. Nominee of Joeu McMenemyh to Juvenile Court Bench. Honorable Council members, the child welfare system in the Commonwealth needs reform, and the first place to start is the choice of juvenile court judges. I write this letter regarding my experience with Ms. Joeu McMenemyh to advise you of the facts which I believe adversely reflect on Ms. McMenemy's qualification for this judicial opening. During what was later determined to be a frivolous prosecution on my wife and I for parental kidnapping, Ms. McMenemyh behaved in a manner which was routinely inappropriate over a period of about 1 year. What follows are but representative examples of proverbial false statements Ms. McMenemyh made to the district court at my bail hearing. I know, however, that at virtually every hearing in my case, Ms. McMenemyh made false statements or evidenced a lack of knowledge of the laws under which she was supposed to operate. The sheer volume of materially incorrect statements made by Ms. McMenemyh in this case, whether deliberate or negligent, indicates that no court should place in any confidence in her statements unless they are independently corroborated. These statements are indicated at Ms. McMenemyh's places advocacy above, justice in her practice of law. A multitude of additional false statements as well as the supporting proof can be provided upon request.
Do you want to read all those, or do you want us to read them?
You can read them.
That would be fine. I mean, it's a long statement.
We just asked that it be admitted.
Well, we'll make this a part of the record. And if that's satisfactory to you, then we'll read it. And if you have any other comments you'd like to address, or add anything in addition?
Not Ms. McComb, no.
Okay.
On my own behalf.
On your own behalf, if you'd like to address the council?
Yes, I will.
And let me just say, I do understand that Ms. McMenemyh's been involved in a number of cases that have people with strong views about, and we welcome the input of people who have experiences with her who want to share some observations with us.
Yes.
What we can't do here is we cannot retry any case that was tried in the court. So I just mentioned that to help you out in terms of what we'll be looking for by way of information from you.
Okay, thank you. I would like to reference my notes. I was subpoenaed to a trial in Pittsfield, Massachusetts. Ms. McMenemyh was the district attorney to try the case, affidavit by my brother. In her closing argument in the court, she had stated to the jury that they must find my brother guilty of raping his daughter Tracy because he stuck his finger in her vagina and pulled out a pinworm, as it was testified at the trial that my brother's daughter had pinworms. Upon looking at the jury, I realized that that statement was an impact on them. In turn, we sent a letter to Judge Curley reflecting that that was never testified to at the trial, that my brother never penetrated his daughter with his finger. And thus, the jury came back with a question to the judge, which I have a copy here, stating, can the jurors receive more information regarding the medical confirmation or medical definition and symptoms of pinworms, how the pinworms were transferred, and what part of the body they can be found?
Let me ask you a question. Was your brother represented by counsel during this hearing?
Yes, he was.
And was he convicted?
Yes, he was.
And did he appeal on any of these issues?
Yes, they did.
And is the appeal resolved, or is it still pending?
His appeal is
referring to here about evidentiary concerns, were they raised in that appeal?
Yes, there were. I have a copy of the appeal. I would like to add that to the record.
You can certainly add it to the record, but I guess I just would observe for you that we're not here to sort of second guess a process that your brother was represented by counsel and had an opportunity to be heard before a judge, and decision was made by a jury, and then it sounds like a number of the courts have reviewed it on appeal.
Mr. Chairman,
Yeah.
by the way, I'm Mary Petito Damiani, and I'm sorry I'm late, but there was a big hole on Rock 93, and it was maybe an hour late on where I was coming from. I don't know how you people make it, but it's great. I just want to say that we have public hearings, and every person is allowed to testify for or against, and not to be interrupted. And I invite anyone who's in opposition to be in full and not be interrupted, and that's the rule. This is public.
All right, wait, let me just respond. Actually, the rule is I'm running this hearing, not counsel.
Point of order. You don't run the hearing.
I am running this hearing, I am chairing the hearing, and I will set reasonable parameters for witness testimony, and you'll need to listen to me or you won't be permitted to testify. Now, it's unfortunate that you're getting involved in a little dispute between Maryland and Maine that seems to be happening.
Point of order supersedes all parliamentary procedure, Robert's rules. As a counselor, it's not your court. It's not your court anymore.
It's not yours either. What would
That's
you like
right.
to say?
It's the people.
Councilor Manning.
Point of order.
What would you like to say?
The people
Address
who are
the chair,
here.
please.
They shouldn't be
I can look
badgered.
out the door if I'd like to look out the door.
I'm asking you to address the chair.
They should be badgered.
My point of order is this. I would like to hear from everybody without them being cross-examined. We did not cross-examine the people who are here in favor, and I don't believe that it's appropriate to cross-examine the people who are here opposed.
Well, I agree with you,
And-
but nobody's
and
cross-examining
please-
anybody.
Please, and in addition, while it is true that we don't sit here as a super court or a super jury over a trial that's already taken place, we are here to impose our own individual lenses on this nominee and her ability to be able to sit impartially on the bench. And part of that is to hear information from all sources. I am neither a super jury, nor am I hampered by the fact that a jury has convicted this man's brother, and the appeals court didn't see the value of the appeal. Those things are of no moment to me, just as apparently you want to, or some might discard this man's testimony because his brother was convicted. I am not going to discard this man's testimony because of that, and I would like to be able to hear it, sir.
Well, that's fine. And you stay out of it, Councilor Devane.
Point of order.
Forget the point of order. The Councilor Devane needs to abide by the rules of the
So do you, point of order?
I just ask that to the chair that we, as a topic is room the hearing, I think the gentleman has a little more to share, and the other people, I've been hearing him, I'm hearing your questions.
All right, sir, why don't you continue? Keep in mind the comments I made.
And now mine as well, thank you.
I would also like to bring it to the attention that in the beginning of my brother's case, there were 3 victims that come forward in the beginning against my brother. His 3 daughters. 2 of the daughters, in the very beginning of the case, said that their brother touched him, not their father. I have a state police record conducted at the kid's place with the same interview, where the girls are quoted as saying, and I will quote one of the victims, her name is Kelly Litchfield. Kelly said my brother Jay wanted to do it with me. Kelly said when she did Jay, it happened down the stairs inside the house. Everyone else was in the parlor watching TV. Kelly said Tracy came down the stairs and I just stopped. Kelly said Mom knows because Tracy told her. Kelly said Mom thinks someone's touching me down there. I tell her no. I wiggle a lot. She thinks I'm humping the chair. I just always move around a lot. That was on May 8th, 2000. On May, I want to say 17th of 2000, my brother was indicted for Kelly Litchfield in a grand jury hearing conducted by Ms. McMenemyh. The story changed from Jason to her father.
Are you done?
Okay. Then, 2 years and 2 months later, my brother was brought to trial for molesting 3 daughters. It's documented through DSS records that 2 of the girls blamed the brother. Jason was removed from the home in November of 2000 and branded a juvenile sex offender. That information Ms. McMenemyh had at the trial was kept out of the trial. Here's page number 4 of the trial transcript, and it's quoted as saying, Attorney McMenemyh, thank you, Your Honor. First order of business, Your Honor, there are 2 indictments the Commonwealth would like to file a novo prosecute. They are indictments 197 and 198. These are 2 indictments alleging indecent assault and battery on a person under 14, and they allege it's the same victim, Your Honor. In each of those indictments is a person named Kelly Litchfield. Mr. Green, any objections to that? Attorney Green, no objection. The court, does this mean there are now no allegations involving Ms. Kelly Litchfield, Ms. McMenemyh? That is correct. But she indicted him on her. Here's a copy of the indictment transcripts. And pretty much word for word is what all 3 girls testified to. This is after they accused their brother, which that information was suppressed at the trial. I know this because I was subpoenaed to the trial. And I have a copy of my subpoena here. That is false. Jason was removed from the home in September and placed in the KEY program and branded a juvenile sex offender by DSS. And I have a copy of the KEY program evaluation, and on the cover page it says, this is a complicated case with many players. Good luck. This I would like to be evidence.
You have copies of those documents, sir?
Yes, I do, sir. By reviewing, I sat through the trial, and by reviewing the trial transcript, like I said in the beginning, her closing statement where she said to the jury that my brother reached up inside of his daughter's vagina and pulled out the pinworm. When I turned around and saw the impact it had on the jury, I realized that was important. But not being a lawyer, I didn't understand the protocol or the ramification of it. Upon reviewing the trial transcript, after me and my sister had signed on as powers of attorney for my brother, and reading the trial transcripts, it is my conclusion that the trial transcripts are altered, and I can prove that. I sat in on this trial when the statement was made, and if you give me a moment to find the trial transcript, I will find the closing argument.
And who do you think altered it?
Excuse me?
Who do you think altered it?
I have no idea. I have a letter from my brother's first appellate attorney, which is James Metheny, and this is what the letter states. I just have to find it. This is to update you on the status of the transcripts of your trial. I made a call to Berkshire Superior Court and ended up leaving a message for the court reporter that had yet to finish her portion. The court reporter left me a message on Friday that she had had hearing surgery on September 29th and just returned to work on November 10th. She is under doctor's orders not to type until January. She wants me to call the first week in January, and she will tell me when she thinks she can finish it. Apparently, the information that I received in September that she was finished but was proofreading is not true. And in the trial transcripts, page number 40, this is what the transcript says. When he touched her on the inside of her private. That is all it says. But that's not what was said to the jury. And I stand here before you today, I heard it. And we have been going at this for 8 years with my brother, under legal consultation. Not coming here shooting from the hip.
No, thank you.
You're welcome.
All right.
We are trying to bring this to the attention. We have been to the Attorney General's office. We've been to the senators. We've got all the correspondence and letters from them. And now we're in front of the governor.
Thank you. Councilor Byler, did you have something?
No, I was just trying to
Okay.
figure out.
All right, Councilor Manning?
I wasn't here when you introduced yourself. Are you
Richard Litchfield?
Richard Litchfield? So is this on the letter that you submitted as July 14th, 2002 letter?
Yes, it is. My signature's on it.
Okay.
And it states also in Ms. McMenemy's part.
I just have one question that I wanted to ask you about this.
Okay?
Do we all have a copy of that?
It went all around, so I'm going to just...
Oh, I'm sorry, that's the
No, that's no
take
problem.
home, take home letter? Okay.
Yeah, that's no problem.
Mine dated August 3rd, that's why.
Well, then it's not the same one, so you was like... Yeah, it's on the...
The other one's...
It's on my desk. I mean, it was sitting in front of me. I assumed it went to everyone. Can you get this one? That was right there. In that letter, the July 2002 letter, on the bottom of maybe the third page, it says that there was an allegation that Attorney McMenemy was with the jury when they deliberated. Do you want to see that letter?
Yes, sir. It's been 8 years.
Isn't that a copy?
That's the July 14th, 2002 letter to Judge Curley.
Yes.
And I've recently gone through a divorce, so it's kind of like
I have the one that I gave you, counsel, that I got circle the paragraph. Is that the one I gave you, counsel?
This one does not have a circle paragraph.
Well, I'll look forward, if somebody else has a question, I won't hang anybody up. I'm going to focus on that one part of the letter if I can find it.
Anybody else have any questions? Yes, Councilor Foley?
Just my own understanding, the issues that you brought up here, you have appealed them in the courts, correct?
Yes.
And most of it's been adjudicated at this point.
Yes.
And
But my brother's not the only legislative case. There's other cases that have gone through the Berkshire County District Attorney's Office that have been overturned after they've gone through the appeal.
I'm concerned with your allegations right now.
Okay.
So is that it as far as your appeals go? I'm just trying to understand, your appeals have been exhausted at this point?
Yes, I believe so.
Thank you.
You're welcome.
I found the
All right, Councilor Manning?
in your July 2002 letter, you
Okay,
have
do you
down
want-
here at the bottom about the, looks like it's page 1, 2, 3 of the typewritten text. Where it starts and says, much factual evidence was suppressed in the case, including Assistant DA McMenemy's being allowed to stay with the jury during deliberations on May 17th,
That was with the grand jury, yes.
2000. Oh, that's with the grand jury.
Yes.
Okay. Then I misunderstood what you said. Now, during the closing argument, you were there?
Yes, I was.
And Mr., I'm sure that your brother had an attorney there?
Yes, he did.
Did the attorney object at all during the closing argument?
I have this here, and I was reading through that. I believe this is from the appeal from was something about Attorney Green objections of the conspiracy.
Okay, so there was a point where he might have objected.
Oh, yes, as in everything, the first appellate attorney did a very, very, very thorough job of summing up the case right here.
Okay.
I've read through it and I'm convinced that this is, and I would testify that that is pretty accurate to exactly what it was.
Okay, so then was there an objection made to the part about the continuum portion of the closing, the part that you said it passed the jury?
I'm not sure at this time because it's been 8 years and like I said,
You
this
know
was the magnitude of the case for me and my
Yeah.
sister to take on top of 6 days later, my nephew was killed. My
Right.
brother's witness at the trial was killed in a crosswalk in Pittsburgh. So we went through my brother getting convicted, right into that. And me and my sister are powers of attorney for my brother. And we also went after the administration and took that on at the same time.
So your memory's not perfect, and I appreciate
Then I
that.
went through a divorce. So I'm kind of sketched.
Yes,
I stand here firm what I'm saying today.
Sure, I understand.
But I have to put my finger on that.
I just wanna say something, and that's that, when somebody does an appeal, I'm not a, professional appellate attorney, but I can tell you that generally, if an attorney doesn't object to something at trial, then that whatever the appeal is lost from that point.
No, there was-
Hold on. I'm making a point of my own, and that it doesn't matter to me whether the attorney objected or not. If a prosecutor is engaging in prosecutorial misconduct,
Yes.
in my opinion, not in the opinion of an appellate court, or whether or not it was objected to at trial, I want you to know that, and I don't think I'm alone in this, that's very serious accusation that I take very seriously, and I know other people here do also, and we will make sure that, I will make sure that I am confident in how I consider and how I conclude on this nominee. I know it's very difficult for you and your family exposing yourself in this way, and a lot of empathy for you and your family, and I'm very thankful that you came here today, and it's very important that we're involved in it.
And I would also like it known that we did use our chain of command. We've gone from Berkshire County all the way here. We've been to Boston a couple times. And they keep sending us back to the district attorney's office where it took place. I've called the district attorney's office to sit down to talk to Mr. Capeless and to Joan about the case. Because like I say, 6 days after my brother was convicted, his son was killed. There's hundreds of evidence for that.
Thank you. Obviously, this is a very disturbing situation, but can I just ask, you are here to say that those closing statements
Impacted the jury.
impacted it, and that is, let me just step back.
That was,
Let me just ask another question, if I could, to the chair before I go to those. Being in with the grand jury or Robert, is that illegal activity? Okay.
Happens all the time.
It's illegal activity?
No, it happens all the time.
So, do you realize that even though you say that it was with the jury, you're saying that the attorney, asking here was with the grand jury, you're saying that should not have happened? And we're hearing that is not uncommon.
I'm
I
not.
just wanted to say that you know that, because I want to understand what I'm evaluating, because this is very serious.
What I was saying about the grand jury minutes was the fact that, according to the police report, the same interview, Kelly was blaming her brother. And then 3 months later, my brother's indicting on Kelly at the grand jury.
This was, and I heard you, and I, again, very sensitive, and I feel you're, this is very serious stuff. But what I'm trying to say is, you say that DA Max McMenemyHearingAugust42010966 being allowed to stay with the jury, so that was, you expressed that as a complaint, and I'm saying, would you agree then that that would not be a complaint? I just want to understand what I'm evaluating, because that was something that was legal, lawful, permissible?
Yes, I would say yes.
Okay, I'm just trying to fix, so therefore, what you're saying is the statement, which was obviously, we don't have to repeat it again, we all heard it, it's very serious, very, powerful statement, and you're saying since that was not true, it never came up in the trial, but that was too impactful and had an
That was
impact.
also brought up on appeal, too.
Would you also say, though, that there was what you did say, though, just so I can, again, I just want to fact here so I know what to do, that there was testimony, though, about pinworm,
Yes,
the exact location, which was in the proximity of what
that's correct.
DA McMenemyhe said,
That's correct.
did in fact get stated at the hearing, at the trial. In other words, there was a pinworm,
Yes.
there was one within a very close proximity of where you just explained, but it wasn't the exact proximity. Is that your...
Yes. It was on her lip, but he never stuck his finger in her to pull the pinworm out.
So there was one, it was there, he did admit to something.
Oh, yes.
It wasn't exactly the same location.
My brother was an EMT, a licensed EMT.
Okay. I'm just trying to get that, because I did read that here.
And it is documented where he called the pediatrician and explained that she had pinworms. He described the pinworm to the pediatrician, and they prescribed medication for it.
Okay, can I just ask you one other question?
Yes, you may.
Aside from that statement and the one we just talked about with the jury, was there another accusation that you would like to make against Ms. Nominee so that we could clearly understand?
Yes. Well, his youngest daughter, Frankie, it is noted in the 51A, which my sister will be presenting, was abused before she came into the Department of Social Services care. I witnessed Ms. McMenemyhe at the trial using that medical evidence to target my brother and say he did it. Never once did the jury know that that child was touched before my brother adopted her. That was kept out of the trial. The 51A was kept out, and the information on it.
We're going to hear about that.
It's in the paper.
Thank you.
And let me, by the way, introduce Councilor Timothy, who's joined us.
Thank you.
I'm sorry, did I not introduce you?
Thank you. No,
Oh,
that's okay.
I
I
apologize.
introduced myself.
I apologize.
I want to thank you for coming. I think this is a public forum, and I want all the information I can. Yeah, and I really am pleased you came because it takes a lot of courage. And a lot of courage to say, and believe me, I'm really disturbed reading the letter by attorney Michonne. And
Louis Paconi.
yeah, well, it's okay, Paconi.
He wanted to be here, but he couldn't.
Okay, I appreciate the letter. It's very powerful, and I think, when this man says that virtually every hearing in my case, Ms. McMenemyhe made false statements or evidence the lack of knowledge of the laws under which she is supposed to operate, and she avoids a material incorrect statement in this case, whether it's deliberate or negligent, indicates that no court should place any confidence in her statement unless they are independently corroborated. And he points out all of these false statements, and that's very disturbing to me to think that I can't judge this case. I'm not a lawyer. I just whatever you are feeling. Is that correct?
We have.
Okay.
We've
The thing is that to accuse your brother of molestation when it happened before he adopted the child,
was kept out of the trial.
that's disturbing. Believe me,
And she has the documents to prove it.
believe me, I appreciate this, and I will do all due diligence.
Thank you.
Thank you. All right.
Before you go, I'm going to sit you down with one of our interns.
You can see Mr. Cronin after the meeting, and he'll help you with that.
We can't do that. We're going to wait to another copy of your full rate.
All right?
Ready to give it to this?
No, if that's your original, we'll have.
No, these aren't the original. This was the copy we brought to present.
All right, and we'll take that for the record. All right, thank you. All right. All right. And would you like to speak? Yes, would you identify yourself, please?
Yes, my name is Robin Litchfield, and I would like to thank you for allowing me to speak today in regards to the possible appointment of Attorney Joeu McMenemy as juvenile court judge. I would like to begin by giving you a brief background in regards to my character. I have an associate's degree that I obtained while serving 8 years honorably in the United States Navy. I was an aviation electronics technician with a secret clearance. I am a substitute rural carrier for the United States Postal Service. I work full-time for the payroll department of Berkshire Health Systems, the largest employer in Berkshire County. I just recently received my reappointment as notary public. My observation of Attorney McMenemy stemmed primarily from her wrongful, overzealous prosecution of my brother Paul, rather than seeking justice. Instead, she sought to enhance her political career at the cost of innocent lives. My brother is currently serving 16 to 24 years for sexually abusing his adopted daughter. My brother was approved by DSS to be a foster parent in 1982. Over the years, him and his late wife, Lori, had in excess of 100 foster children, and their care of whom they adopted 4 in 1994 with not one incident of sexual misconduct. 3 of the 4 children were biological brother and sister, Jason, Kelly, and Tracy. The 4th adopted child was a daughter named Frankie, who was a victim of fetal alcohol syndrome and classified as retarded. There were no supported allegations of any kind against my brother. There were, however, supported allegations of physical abuse of the children by their late wife, Lori, ultimately closing the foster home. In December of 1999, DSS investigated allegations that the youngest daughter, Frankie, was sexually abused because the school nurse diagnosed her with vulvovaginitis. Frankie had a history of bedwetting and frequent bouts of vulvovaginitis, and I have the documents in here. In the DSS document, it is noted that Frankie was horribly sexually abused while part of a cult before coming into care. In January of 2000, my brother left the marital home and began an extramarital relationship with another woman. In March, Lori went to DSS with allegations that my brother Paul had sexually abused his daughter. Lori, at the urging of the DA's office, state police, and DSS, obtained a restraining order. I have a voicemail which we state. 10 days after the restraining order was put in place, Paul's oldest daughter was taken to the pediatrician due to a swollen labia. Paul was never arrested for this incident. The pediatrician testified that Tracy was never violated, that the hymen was intact. As well, Dr. Moreno was the girl's pediatrician since 1996, and being a mandated reporter, never filed a 51A. Kathy Watson, the nurse practitioner for Dr. Moreno in January of 2000, stated there was no medical evidence of sexual abuse in the medical record. In September of 2000, Jason was removed from the home with an alleged overdose. In November of 2000, due to allegations by his sisters, Jason was put in a key program classified as a juvenile sex offender. Jason discussed on numerous occasions with my brother Carl the coercion of his sisters at the hands of DSS and their adoptive mother. My brother was a licensed EMT at the time that these allegations were brought forward. Attorney McMenemy went to the length to ensure his license was revoked by labeling him a risk to society, therefore invoking the expedition of his Court Rule 36. However, it took her in excess of 2 years to bring him to trial. Attorney McMenemy was aware of the above facts and many others regarding my brother's case. Rather than investigating these issues, she chose to manipulate the evidence in order to gain a wrongful conviction. Jason was on the Commonwealth's witness list. In March of 2002, Jason's life was threatened in an email from Daniel Roy because he was tired of the lies and wanted to tell the truth. Daniel Roy is Lori's biological son. Attorney McMenemy was aware that Jason's life was threatened and did nothing to protect him. On July 17, 2002, Jason told 5 family members, including myself, about the coercion of his sisters and others, by DSS and others. This was brought to the attention of Judge Curley prior to the sentencing, which was supposed to take place on July 18th at 3:30. Judge Curley delayed the sentencing. On July 18th at 5:15, less than 2 hours, my nephew was killed in a blue painted crosswalk in Pittsfield by the son of the people he was living with. These people were long-time family friends of my brother's ex-wife. Lori and her biological son, Daniel Roy, were observed by a Superior Court official as having appeared in the court on July 18th and left in a huff when they realized the sentencing was delayed. Daniel Roy and Robert Smith Jr., the man that killed my nephew, are close friends. A paramedic who arrived at the scene told me that he has been a paramedic for over 27 years and has never seen so much blunt head trauma with no blood at the scene. The DA's office investigated this incident, and to date, no charges have been filed against the driver. Jason's estate is still in probate, and Attorney McMenemy is on record as saying Jason had nothing to do with his father's criminal trial. It is not until after Jason's death that the Commonwealth released a preponderance of exculpatory evidence that was in Attorney McMenemy's possession prior to my brother's trial. My brother's case is not an isolated case regarding someone being wrongfully convicted out of Berkshire. Bernard Barron's conviction was recently overturned. Michael McLaughlin's case was taken to the Supreme Court of the United States, and the convictions were ultimately overturned. Both cases had exhausted all appellate process and ultimately brought forward by attorneys who sought to seek justice for wrongfully convicted people. I feel that through her actions, suppression of evidence, not thoroughly investigating the allegations, and not protecting a material witness, that an innocent person was wrongfully convicted of crimes that he did not do, and the true perpetrator, his son, who is coming forward with the truth, was murdered. Because of this, I feel Attorney McMenemy should not be awarded for her questionable behavior by being granted judgeship. She has shown through her actions that she is not there to protect the best interests of the public, but rather appears to be more interested in furthering her political career prospects.
Thank you. Before I see if any councilors want to ask any questions, let me introduce the councilors that come in. Councilor Iannella on the far right corner, and Councilor Callahan on your right. Thank you. Councilors, any questions? All right.
I'd like to touch on two things. The thing about the indictment, I'm the one that put that in the subpoena. I'm a layman. I'm not a lawyer. I did not know it was permitted, but I put it in the ring. As far as my brother, there is a private investigator on his case.
All right. Councilor.
I have a question to ask. You. On the nominee's questionnaire to advise the council of anything favorable or unfavorable, she said that she has handled matters with such and such. She said that she didn't document it, but she said that none of the parties have filed a complaint with the Board of Bar overseas, and none of the parties have filed a post-conviction motion for relief in a criminal matter or had a successful appeal of the criminal matter. B, in 2000, a complaint was filed with the Board of Bar overseas by a defendant who questioned whether I withheld exculpatory evidence or violated a pretrial discovery order in a motor vehicle homicide case. The judge who presided at trial and who dealt with the issue and raised the trial determined that I did not violate the discovery order and that the information was not on its face exculpatory. When the defendant filed a complaint with the board, I responded in writing. The board dismissed the complaint without hearing, and the matter had been expunged from the Board of the Bar overseas record. I know what you just said, but it pertains to you.
I don't believe it.
Well, that was not a homicidal? Okay, I take that back, what you said about your nephew.
It's still in family probate. It's still an open case
Okay.
in 2002.
Did you ever notice the bar overseas?
We filed a complaint with the Board of Bar overseers when our nephew was in CCU, and the whole paternal Litchfield family was banned from seeing him at the hands of DSS. And I've done nothing to him.
This is really strong. I've never seen anything like this before, to have such evidence, but,
A 16-year-old boy lost his life, and there's not one person who's been remorseful for it.
Councilor Pyle has a question.
I was just gonna ask, so you did put a complaint with the Board of Bar overseas?
No. No, that is not us.
No, that is not you. The question I know Councilor Ray asked, did you, and I thought you said yes. You
Oh,
have
sorry,
not.
I thought you said.
You have not filed do that, or you were not advised by attorney?
I was advised and I was told it's outside the statute of limitations, yes. I did go to the ACLU and everything. We have gone up with James. We have come to the Attorney General's office. We have spoken around about it.
Thank you. Anybody else wish to be heard? All right.
And I have this,
Are those original or
no, these
are
are
they copies
copies,
for us?
along with my letter.
Yeah, those, if they're copies for us, all right, yes, sir.
My name is Patrick McDavid from Hyde Park. I work with the Fatherhood Coalition. We had not anticipated making a statement today. We are not particularly well-versed with juvenile court. Although our membership has plenty of problems with the courts, luckily most of them don't get involved in juvenile court. Our major issue are children and fathers. We're concerned about what we perceive as widespread child abuse by our courts. We believe that the courts are the biggest group of child abusers in this state. And we look particularly at the probate court with what is going on. Sir, you've asked me before where those facts came from. Since that time, it's been in the paper that in 1989, the state itself did a study on custody matters. I know that's what they like to hear, but I just wanted to clarify that out. And following in 1999, independent party did a similar study on Worcester County alone, showing the state in custody cases. I had said before 85%, I was incorrect, 90%, and in sole physical custody. Our only point is
based on the 1999 study.
Both the 1990 study is that sole physical custody is 90%.
Has that been updated at all?
No, we have asked Justice Carey if she would update them. She's declined to give us any numbers. Our issue is the court and their interaction with children. We think there's room for a lot of improvement. I'm a bit concerned when I hear members of the bar try to claim that the courts are doing a great job. I don't know what basis they would put that on. It would be something else to say, and hopefully we're going to hear from this candidate that if she becomes a justice, that she's going to work very hard to make the court an honorable place, rather than what I would not want to hear is the assumption that the court is doing a great job and does need to do better. I think there's a lot of room for improvement on all levels of the court as far as our children go. I'm very disturbed to hear what I've heard from these other people, and I'm also aware that the investigation that is done before it gets to this level sometimes is not complete. And I would hope you would do right by the people of Massachusetts and also right by this candidate to look into this matter, to clarify it, to see if they meet the standards that you think are appropriate for a justice of the court. Again, our concern is the welfare of our children. We're very concerned that the courts are not really meeting the standards of general public elections.
Thank you very much.